Hi, Robert Eckert here, your board certified business litigation attorney and government investigation specialist. Today's video will be a follow-up to the previous video that was done on money laundering. Today's video will deal with how whistleblowers can get awards for reporting money laundering or sanctions violations. A lawyer's whistleblower's guide to the Anti-Money Laundering Whistleblower program. To strengthen the enforcement of an anti-money laundering program and bank secrecy regulations that Congress enacted, which included the Anti-Money Laundering Act of 2020, the AMLA Whistleblower Rewards Program requires the Department of Treasury to pay awards to whistleblowers who voluntarily provide original information leading to successful enforcement actions for AMLA violations. Recently, Congress strengthened the AMLA Whistleblower Rewards Law by enacting the Anti-Money Laundering Whistleblower Improvement Act. Number one, establishes a minimum award of 10% of collected monetary sanctions. Two, creates an anti-money laundering and counter-terrorism financing fund from which whistleblower awards can be paid from sanctions collected in successful enforcement actions stemming from whistleblower disclosures, and expanding the AMLA whistleblower law to reward disclosures of sanctions violations, i.e. violations of the International Emergency Economic Powers Act, and Sections 5 and 12 of the Trading with the Enemy Act and the Foreign Narcotics Kingpin Designation Act. Congress included the Anti-Money Laundering Whistleblower Improvement Act in the Consolidated Appropriations Act of 2023, which President Biden signed on December 23, 2022. What is the Anti-Money Laundering Whistleblower Program? The AMLA Whistleblower Program incentivizes whistleblowers to report money laundering by requiring the Department of Treasury to pay an award of 10% to 30% of collected monetary sanctions that it recovers in a judicial or administrative action brought under the Bank Secrecy Act that results in sanctions exceeding $1 million. The Anti-Money Laundering Whistleblower Improvement Act expands upon the AMLA Whistleblower Program to encompass whistleblowing about violations of U.S. sanctions, i.e. violations of these statutes: the International Emergency Economic Powers Act, Section 5 and 12 of the Trading with the Enemy Act, or the Foreign Narcotics Kingpin Designation Act. Now, to qualify for an award, the whistleblower must voluntarily provide original information to their employer, Treasury, or the Department of Justice. The AMLA Whistleblower Reward Program is modeled on the highly successful Securities and Exchange Commission Whistleblower Program. Since its inception, the SEC Whistleblower Program has enabled the SEC to uncover significant investment fraud schemes and halt the ongoing fraud. Since 2011, the SEC has paid more than $1.3 billion in awards to whistleblowers for providing information that led to successful enforcement actions. According to a recent report of the SEC Office of the Whistleblower, enforcement actions brought using information from meritorious whistleblowers have resulted in orders for more than $6.3 billion in total monetary sanctions, including more than $4 billion in disgorgement of illegally gotten gains and interest, of which more than $1.5 billion has been or is scheduled to be returned to harm investors. So who is eligible for an AMLA whistleblower reward? In contrast to the SEC whistleblower program eligibility rules, the AMLA Whistleblower Reward Program does not impose limitations on award eligibility for whistleblowers who gain information through the performance of compliance or audit job duties. Indeed, the AMLA Whistleblower Law expressly authorizes compliance personnel to obtain AMLA Whistleblower Awards that the term whistleblower includes an individual who provides information relating to a violation as part of the job duties of the individual. Non-U.S. citizens are also eligible for AMLA whistleblower awards. Can a whistleblower report money laundering or sanction violations anonymously? If represented by an attorney, an AMLA whistleblower may submit a tip anonymously to FinCEN, and the AMLA Whistleblower Rewards Law requires Treasury and the U.S. Department of Justice to take steps to protect the confidentiality of AMLA whistleblower submissions. Any officer or employee of either agency must not disclose information provided to the whistleblower, which could reasonably be expected to reveal the identity of the whistleblower, except where the agency is required to disclose the information to a defendant in a public proceeding instituted by the agency in accordance with the Privacy Act. So how does the AMLA Whistle Program reward determine the amount of an AMLA whistleblower reward? To determine the amount of an AMLA whistleblower award, Treasury will consider these factors: the significance of information provided by the whistleblower to the success of the covered money laundering or judicial or administrative action, the degree of assistance provided by the whistleblower and any legal representative, the pragmatic interest of Treasury in deterring the particular violations that the whistleblower disclosed, and any additional relevant factors that Treasury will promulgate, which will likely echo the factors that the Securities and Exchange Commission employs to determine the amount in SEC whistleblower award. How will FinCEN pay AMLA whistleblower awards? The Anti-Money Laundering Whistleblower Improvement Act established that the Financial Integrity Fund to pay whistleblower awards. Monetary sanctions collected by the Department of Justice or Treasury in any judicial or administrative action stemming from an AMLA whistleblower disclosure are deposited into the fund until the balance of the fund exceeds $300 million. Are AMLA whistleblowers protected against retaliation? Yes. Section 6314G of the AMLA creates a private right of action for whistleblowers who have suffered retaliation for disclosing potential Bank Secrecy Act violations to Treasury or Justice, a federal regulatory or law enforcement agency, Congress, or a person with supervisory authority over the whistleblower. It also protects a whistleblower assisting in any investigation or judicial or administrative action of U.S. Treasury or Department of Justice based on or related to the information that the whistleblower disclosed to the government. A prevailing whistleblower in an AMLA whistleblower retaliation claim can obtain reinstatement, double back pay with interest, uncapped compensatory damages, reasonable attorney fees, and any other appropriate remedy with respect to the conduct that is subject to the action. If you have further questions about this topic or any other legal matters, please feel free to reach out at me at Robert@Robert Eckerd Law and like this link below.